I'll get another one.
Is Mr. Smith lodged?
In the Wexford County Jail, Your Honor. I don't know if they brought him over.
Looks like they're connecting right now. So. While we're waiting for that, do we have Mr. Christie?
Yes.
Do you want to take that one, Mr. Seeger?
That's fine, Your Honor. Whatever order.
Okay, if we could bring Mr. Christie up. All right, Mr. Christie, if you can come to the podium there for me, please. We're on the record now. This is People versus Blake Christie, case number 244933. The record should reflect that Mr. Christie is present here in the courtroom today. If I could have counsel put your appearance.
Ryan Ziegler on behalf of the people, Your Honor.
I'm Cedar, appearing with on behalf of Mr. Christie.
Thank you. This is the date and time set for sentencing. I know we've got an issue with regard to a couple of the scoring guidelines, but before we get into that, Mr. Christie, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
I believe we talked about it.
You need more time to do that before you go forward tonight?
I think we'll be fine.
Okay. Mr. Seeger, are there any additions, deletions, or corrections?
Not to the body of the report, Your Honor, only as it relates to the scoring.
Okay, so the first scoring challenge is with regard to OB11. I did have a chance to review your memo, Mr. Seeger, as well as your response, Mr. Ziegler. Mr. Seeger, was there anything that you wanted to present in the way of oral argument?
Your Honor, if one, I would largely rely on that brief, but the next thing I would say, and this is somewhat repetitive because it is stated in proof, one, that the sentencing offense is criminal sexual conduct in the second degree, which does not require penetration. Second, the case that cited Haynes is an unpublished decision, so at best it's persuasive. Next, even if the court did find that law to be persuasive, I think that it's factually distinguishable in as much as in the Haynes case that was cited. There was, at the time of the plea, there was a admission to sexual penetration, which was not the factual basis in this particular case. Additionally, there was a transcript, Your Honor, for which the court relied on that to come to a determination that that particular variable should be scored. And that OB11 specifically states, do not score the one penetration that forms the basis of first or third criminal sexual conduct, MCL 777-2412C. So as far as I can tell, Your Honor, and as much as I can appreciate what the prosecuting attorney is arguing, it does not appear to me that it would be properly scored under that particular variable.
Thank you, Mr. Ziegler.
Your Honor, I largely rely on my brief, but just to address what Mr. Seeger had said about Haynes being distinguishable, I don't think Haynes is distinguishable just because in Haynes, there was an admission at the time of the plea versus here where there's not. The court can always find facts at the time of sentencing based on a preponderance of evidence. The court has sufficient facts contained within the PSI to determine that a penetration more likely than not did occur on at least one occasion. I would also note that McGraw specifically exempts scoring variables where they, by their own terms, reference facts and circumstances outside of the sentencing offense, which is the case for OV 11. So for those reasons, Your Honor, I think the court can find as a matter of judicial fact finding at the time of sentencing that a penetration did occur. It is not a required element of the sentencing offense here, and that it did spring out of the sentencing offense. So OV 11 should be scored at 25 points.
All right, thank you. Again, I did have a chance to review the briefs. I did review the Haynes case that was attached by Mr. Ziegler. I also reviewed McGraw. Haynes, of course, as Mr. Seeger indicated, is an unpublished case. I do think it's persuasive from the standpoint that it does involve a similar crime here of CSC2, which is the sentencing offense and the offense of conviction. Clearly, there are some factual differences, and there was, a different factual scenario, first of all, but there was also different evidence before the court from which the Haynes court could draw its conclusion that OV 11 should be scored. But I don't think the factual differences are important here, as long as the court recognizes that. I think the important thing is the legal similarities between the issue in Haynes and the issue here. And so on that point, I do find Haynes is persuasive. I don't think Haynes alters McGraw in any way. I think they can be read very easily together. And looking at those two first for the legal conclusion here, I think OV 11 is scoreable if there's an adequate factual basis. I think the point of McGraw is that the court should refer only to the sentencing offense unless there's some statutory language indicating that the court can look outside of the sentencing offense. And in this case, OV 11 does provide that, and I think Haynes highlights that, and that is that the court can look to conduct outside of the offense of conviction. And that is based on the language that the court can consider penetrations that occur or arise out of the sentencing offense. And Haynes does a good job of pointing out the definition of arising out of. And I think reading the McGraw and Haynes together, again, I think from a legal standpoint, clearly OV 11 is scoreable, which leads to the next question, which is there a sufficient factual basis under the facts as we have them here? And looking at the definition of arising out of as set forth in Haynes, I think the penetration here clearly arose out of the offense of conviction under a preponderance standard. There's evidence that based on the statements of the victim, that there were numerous sexual assaults that occurred over a period of years, and that the penetration was part and parcel of all of those sexual assault instances. In other words, it wasn't a separate event that occurred outside the scope of the sentencing offense. In this case, it was part of the pattern of conduct, part of the pattern of sexual assaults, and the penetration occurred as part of one of those sexual assaults. So the court finds that, again, under a preponderance standard, there's sufficient evidence to support a finding that the penetration did arise out of the sentencing offense. So the court finds that OV 11 is properly scored, and the court did not challenge OV 11. Mr. Ziegler, you also raised an issue with OV 13. It's currently scored at 10, and you're asking the court to score that at 25.
That's correct.
Okay. Any argument that you'd like to present on that?
Your Honor, just very simply, the 10-point scoring relates to a combination of 3 or more crimes against persons, property, or certain controlled substance offenses. The 25-point score relates if all the crimes are crimes against persons. In this case, there can be no question that all the crimes involved in this pattern of conduct were crimes against persons. ESI indicates that there were so many offenses, the victim had a difficult time picking out one to talk about. She said that they occurred over a long period of time. They were happening frequently. There are at least 2 others to make the total of 3, counting the sentencing offense, that would count as 3 crimes against persons in a 5-year period. That would justify the scoring of 25 as opposed to 10. It would not change the overall guidelines range.
Mr. Seeger.
And, you know, I believe that the 10 points is accurately scored, and as much as I understand the argument that the prosecuting attorney is making, I would say that Mr. Christie is entitled to due process. The people are considering uncharged conduct. I assume the reason why it was set at 10 points by the probation and parole department is primarily based on what the original charges were and the ones that were dismissed. And so it's difficult for me, I forget the name of the case, Your Honor, but there is a case where it's talking about acquitted conduct, which this is arguably different than acquitted conduct in as much as he didn't have a trial, but it is dismissed. And so the only way you could get to an acquittal would be if you had an actual trial per se, which is difficult because in this particular case, he admitted to conduct that amounts to criminal sexual conduct in the second degree. But like none of these, I understand that it's in the body of the report indicating that these alleged things had happened for a period of time, but there are only 3 charges, 2 of which were dismissed, 1 of which he pled to. And so I think that it's difficult to, you could probably go through the prosecuting attorney manual and find all kinds of different crimes that somebody could arguably have been charged with. But in this case, they weren't charged with it. And for the reason that they weren't charged with it, it shouldn't be scored in my mind. Otherwise, that just allows the prosecuting attorney to say, well, in every instance, 13 should be scored because they could have charged A, B, C, and D. Well, you didn't charge A, B, C, and D. So we should look at what he was actually charged at, because he at least had the ability to meet those charges. He at least had the opportunity to have a preliminary examination on those charges. It wasn't bound over as it relates to anything else. So just as a matter of due process and general fairness, the court, or at least in my opinion, should only consider the conduct that which was charged, not something that somebody is alleging occurred without some kind of proof. I mean, I understand that she's saying that it happened, but just because somebody said it happened doesn't necessarily make it true. I do also recognize the court is using a preponderance standard, but be that as it may, Your Honor, it seems fair that the Department of Corrections presumably took into account what was originally charged, came up with 10 points, then scored as 25 points for those reasons. I guess we could ask the probation and parole department why they scored it originally as 10 points. That's relevant to the court's analysis.
All right. I got a chance to review the PSI as well as OB13. I think it was appropriately scored by the probation officer in the first place. I think that's a scoring of 10 points is what's supported by the facts under preponderance standard. And so the court is going to deny the challenge to OB13 and have that remain scored at 10 points. So all of that being said, there is no change to the guidelines, which remains 19 to 38 months. Mr. Seeger, did you have any other challenges that we haven't addressed?
No, sir.
Mr. Ziegler, do the people have any additions, deletions, or
No, Your Honor.
any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, this is a sexual assault case. I think the report does a good job of laying out the facts and victim descriptions of the offense. This is something that the victim describes has been going on for a long period of time, since she was a very young girl, till about she was the age of 13 or so, and that it happened at such a frequency that she could not even, she had a difficult time recounting particular instances of the offense. She described numerous different occasions where the defendant had sexual contact with her. She also described one occasion where she was digitally penetrated by the defendant. The guidelines in this case are 19 to 38. I don't see any reasonable mitigating factors in this case. I understand that the defendant doesn't have a lengthy criminal history. This is his first offense, but it is a very significant offense. It's an offense against a young girl. It's an offense where he took advantage of his position of authority and his position in the household to abuse that young girl. And so I think a sentence at the higher end of the guidelines is appropriate, despite the fact that he's a young man and this is his first offense. So I would ask the court to give him a Michigan Department of Corrections sentence at the high end of the guidelines. Thank you.
Mr. Seeger?
Your Honor, these are always difficult cases it's difficult to justify anyone's conduct, especially in these types of cases. So I won't try and do that. The only thing that I can say, Your Honor, is that Mr. Christie does not have any appreciable prior criminal history. He is a young man and he is able to change his life. He did report in the report that he had indicated that he's hopeful that he can be a good father to his own child, recognizing some of the shortcomings in his own life. And this is going to be a difficult road for him. There are a lot of negative consequences that come from this. There very well should be. And I think he understands that. But as it may, Your Honor, I do understand why maybe some of his had that he was a victim of abuse at one point in time in his life. It sounds like he didn't have the best family life. He was kicked out of his home at a young age. He's distanced from his family in many ways. You know, it sounds like he said some of the stuff. That's not an excuse for his own conduct, Your Honor, but it is maybe somewhat of an explanation as to why some of these things may occur. Either as a mayor, Honor, he is a young man. He has no meaningful prior criminal history. He's hopeful that he can change his ways going forward. He's willing to get into whatever programming it is that the department will afford him. I would note, Your Honor, that in terms of looking at the guidelines, the overall scoring is for the range would be 50 to 74 points. He's at a total OE of 55 points, so he's at the low end of offense variable points. I would just ask the court to fashion a sentence somewhere towards the lower end or middle of the guidelines, which will enable him to attempt to rehabilitate himself with the full well knowledge that the greatest thing that comes from this is not only incarceration, but the lifetime monitoring, which I think is a very difficult part of any sentencing for somebody who's engaged in criminal sexual conduct, which again is not an excuse for what he's done, but I think he recognizes what he's done is wrong. He's hoping to move forward from this. I think part of it was him accepting fault, which is what he's done, as opposed to trying to go forward and have a trial.
Thank you. Mr. Christie, anything that you wanted to say today?
No, I do not, other than, I don't know what was going through my head when this happened. I feel really bad for it, I do. I'm really sorry that this had to happen. I don't know what I was thinking.
I read through the report. I'm familiar with the circumstances here. There's a lot of information in the report describing the victim's accounts of what took place during the time of these crimes. There's also a lot of information in there about you and your background. I understand that you did have a difficult upbringing, that you were the victim yourself of some abuse. That certainly is the type of thing that can lead somebody to engage in this type of crime in particular. So I do encourage you to get some treatment for yourself that's available while you're incarcerated and even after that, because this is the type of crime that can recur if you don't get some help for yourself. And number one, I don't think you want to victimize other people, but certainly you don't want to spend any more time behind bars, and the next time the penalties will be much more severe than they are even in this case. Looking at the facts of what happened here, there's some things that concern me. Number one, the exploitation of the age difference between yourself and the victim. Clearly, she was somebody at the time that these crimes occurred that would be unlikely to be able to defend herself against an older male. In the fact that you took the advantage of some opportunities when you had her alone, when the adults were out of the house, is concerning to me. That to me is an indication of some, some predatory conduct where you can get away with it, and so you're going to do it when you can get away with it. And then what also concerns me is the amount of assaults that happen over the period of time, which tells me you had plenty of time to reflect on your behavior, plenty of time to decide, you know what, yeah, I don't know what I was thinking when I did that, but I'm not going to do that anymore. And either you didn't engage in that kind of self-reflection about your actions, or you have some kind of compulsion that you can't stop yourself from doing it. In either case, that's a concern to me. So all of those things combined indicate to me that there needs to be a significant penalty here, not only for punishment for you, so that you understand there's a severe consequence to your actions, but also as a deterrent effect, so that you understand that if you do engage in this conduct again, there's going to be significant consequences, and hopefully that's a motivation for you to get the help that you need to deal with whatever's going on that caused you to do this to another person. So for all those reasons, the court finds that an appropriate sentence is 38 months to 15 years in the Michigan Department of Corrections. You do have a credit of 155 days served. The court will order a crime victim's assessment in the amount of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. There is an indication of a supervision fee here. I'm assuming that the court is going to strike paragraph 2 PSI recommendation. You do have the ability to seek an appeal of this sentence, and Mr. Seeger, if you can have Mr. Christie acknowledge his appellate rights, please.
Yeah, for the record, Mr. Christie has executed a copy of his appellate rights to return a copy of the same to the court and just giving him these copies.
Thank you. Mr. Christie, you are managing custody of the state at this time.
I do.
All right, we're going to try and get a hold of Waxford to see why they don't have Mr. Smith available. So let's take a short recess. Able to hear me there in Wexford?
Hello. Yeah, can you hear me?
Yep, thank you.
Okay.
Sir, is your name Ford Smith?
Yes, Your Honor.
Okay. All right, we're on the record in People versus Smith. This is case number 244896. The record should reflect that Mr. Smith is appearing today by video from Wexford County Jail. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people.
I'm Seeger appearing with on behalf of Mr. Smith.
Okay, so this is set as a final status conference today. We currently have trial set for September 17th. So this would be a plea cutoff date. Mr. Seeger, have you had a chance to talk to Mr. Smith?
I have, Your Honor.
And does he want to proceed to trial?
Yes, Your Honor.
Okay. All right, so we'll go forward with trial as scheduled on September 17th. Mr. Seeger, have you been able to make arrangements for Mr. Smith to, have some street clothes and be?
I have not worked that out, Your Honor, but I will work it out in advance of, and if I have to buy him something, then I'll just do that.
Okay. All right, and Mr. Ziegler, do you know whether you've already submitted your jury instructions?
I have not, Your Honor, but I'll do that later this week.
Okay, so if you can submit your instructions, Mr. Seeger, just any objections you have to the prosecutors or any additional that you would like to request.
And Your Honor, just for the court's awareness, we have worked out, and I still need to discuss this with Mr. Smith, some small stipulations. So if I had to take an educated guess, it should be a one-day trial.
Mr. Ziegler?
Your Honor, I think with the stipulations we have, I'll only have 2 to 3 witnesses. A lot of the factual issues will be resolved by stipulation.
Okay. All right. Mr. Smith, do you have any questions at all?
No, Your Honor.
All right, so we'll make sure that Mr. Smith is here, ready to go in Kalkaska for the trial date, and I'll just ask counsel to be ready to go by 8:30 on the morning of the 17th, and go forward from there. Mr. Ziegler, anything else that we need to address on this file today? Mr. Seeger?
No, sir.
Okay, thank you, Mr. Smith. That's all we have for today.
Thank you.
Do you see Mr. Jarbo here this morning?
Your Honor, I'm Lauren File. I'm
Oh.
Mr. Jarbo's partner. And
Oh,
I'll be
okay.
handling the sentencing.
All right, gotcha. Great, if you want to come forward.
Thank you.
Yeah.
Tell them we're signing the packet.
That,
No,
recognize
no
you
worries.
Sitting there.
Mr. Jarbo was the one who handled the plate.
Okay, we're on the record in People versus Schuhart, case number 244936. The record should reflect that Ms. Schuhart is present here in the courtroom today. And if I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Attorney Lauren File on behalf of the defendant John Schuhart.
Thank you. This is the date and time set for a sentencing hearing in this case. And Ms. Schuhart, have you had a chance to go through the pre-sentence report and talk to your attorney about that? And any additions, deletions, or corrections?
We have no corrections to the body of the report. We appreciate how thorough the report was.
Okay, thank you. Mr. Ziegler, any additions, deletions, or corrections?
No, Your Honor.
Mr. Ziegler, anything on the,
Challenges to scoring. Actually.
okay. Do we have an AG on this case?
No, Your Honor.
Okay,
This is my case.
I have one signed in, so I just want to make sure. Anything on behalf of the people then for allocution?
Your Honor, this is a welfare fraud matter. The guidelines are 0 to 1. We reached an agreement for a delayed sentence. I think it's an appropriate sentence. Under the facts and circumstances of this case, this is Ms. Schuhart's first offense. It's a purely financial matter. She failed to disclose some sources of income and receive some welfare benefits. Part of the agreement was that she was to pay the $4,210 in restitution at the time of sentencing. I'm hopeful she has that today. It sounds like she does. And so if that's the case, Your Honor, I would just ask the court to adopt all the recommendations contained in the PSI, put her on a delay. I have every expectation she'll be able to complete that successfully.
All right, thank you. Anything on behalf of Ms. Schuhart?
Yes, thank you, Your Honor. Ms. Schuhart stands before you as a 63-year-old woman. She has never been in trouble of any kind. Early in late 2021, she was diagnosed with some significant health problems, which resulted in her having to take an early retirement. And I think in the throngs of a financial crisis and a healthcare crisis, she did not make the clearest decisions. And that's what resulted in her requesting some assistance with food that perhaps she did not truly need. There was enough money, although there wasn't a ton, but there was enough money, and some of that was not reported. Regardless, she has certainly understands, and she has her check to make restitution today. I think she offered to make restitution when this first came to her awareness that this was an issue. I appreciate the attention to detail in the pre-sentence investigation report. I would echo the requests of the probation officer that Ms. Schuhart be a candidate for a 6-month period of probation under a delay.
Thank you. Ms. Schuhart, anything that you wanted to say today?
Yes, first of all and foremost, I am ashamed to be standing here, of course, but I would like to apologize to the court and to the citizens for my actions. My decision at the time was not well thought out, and I take responsibility for that. Moving forward, I would just like to say that I could assure that this could never, ever happen again. And I'm truly sorry for that.
I did review the report, so I'm familiar with the facts of this case and your background. You don't have any prior criminal history at all. And this does appear to me, just reading through, that this is one of those things that maybe was a rash decision or something that you didn't think all the way through. Certainly, you know, as a community, we have an interest in making sure that any public resources are used properly. And this is a circumstance where maybe they weren't. And so I do think there needs to be a consequence for that, but I don't think jail time is appropriate. I think this is a good resolution of this. It provides for a short period of supervision, which I don't expect is going to be an issue for you, given the general way that you've lived your life. I suspect that this is not going to be an issue, and some fines and costs and repayment. And I think that's an adequate remedy to address what occurred here. So the court is going to adopt that, place you on a delay of sentence for 6 months. The court is going to adopt that delay, all the conditions listed in the report, and your supervising agent will go through all of those with you. Repayment of the restitution, which is $4,210. That's to be paid to the Kalkaska County Clerk, to be dispersed to the Department of Health and Human Services. The crime victims assessment of $130, a $30 supervision fee during the delay per month. Court costs of $325, a DNA testing fee of $60, and a $68 state cost. Because this is a delay, there are no appellate rights at this time. And let's see. Ms. Wagner, did you want to meet with Ms. Schuhart today, or how do you want to handle the follow-up here?
She can come over right now. Thank you.
Okay, so once you leave the courtroom, Ms. Schuhart, if you want to go across the way to meet with Ms. Wagner, and she'll go through further what you need to do. The court, I don't think, has anything else that we need to address. Mr. Ziegler?
There you go.
Yeah, Ms. Pyle.
Nothing. Thank you, Your Honor.
Thank you. That's all.
Thank you.
Let's just mention the supervision fee. Okay, just want to make sure.
Travis, were you ready with Mr. Summers?
Yes, Your Honor. Watch in the back.
Okay. Ms. Brenner, what was the file that you were signing in on?
Taichoki.
Okay, got it. Thank you. I'm just gonna put you in the waiting room for just a few more minutes.
Okay.
We're on the record now in People versus Dustin Summers. This is case number 224654. The record should reflect Mr. Summers is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Summers.
And Mr. Travis, how did we want to proceed in this file today?
Your Honor, we don't have any scoring objections or corrections to the PSI.
I gotta take a short break and grab the PSI here. Files out with me, so just one moment. Okay, we're back on the record in People versus Summers, and Mr. Summers, did you have an opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, sir. No.
Mr. Travis, you indicated that there's no additions to the
Yes, sir.
Is there any challenges to the scoring of the guidelines?
None more.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for elocution?
Your Honor, it's a possession of analogs case. The court will probably recall that we had taken Mr. Summers' plea back in May of 22. Mr. Summers then failed to appear for sentencing in June of 22, and we did not see or hear from him for approximately 2 years before he was picked up. Ordinarily, on those facts, I think I would be surprised to find a recommendation contained in the PSI for time served. But I think reading through the report, given the factual circumstances of his non-appearance, given the fact that he's served over 7 months in jail on a related case, I think the recommendation made some sense, especially in light of the fact that he's been, according to his own report, drug-free for a lengthy period of time. He's been gainfully employed. For those reasons, Your Honor, I would support the recommendations contained in the PSI. I just ask the court to sentence him to time served. hopefully he has righted the ship and continues along.
Mr. Travis.
Your Honor, very much so, we would ask the court to follow the recommendations, and a lot of, as Mr. Ziegler said, I know it would be a hard ask in a lot of circumstances. But even though Mr. Summers didn't initially do the right thing, for a lot of this period, he was clearly in contact with law enforcement. He was clearly in a situation where I would have thought we would have seen him sooner. We didn't. So I understand that the court may not be very happy with him for not appearing in June 2 years ago. It's not as though for the whole period he was running from the system. Obviously, for much of it, he was incarcerated. Not exactly locally, but not that far away. So I do think the recommendations are appropriate. It does appear as though he's doing far better than he's done in a lot of time. Clearly, substance abuse is a problem for him. It's this case, it's the other case. We look back, it's the history of probably most of his problems. So the fact that he's doing better with that is great. He understands that it's not over. He's had discussions with some of his family members and himself. He's not averse to continuing treatment and realizes that this is not I've been clean for a bit, I'm done, I'm okay. He understands that this is a road that he's got to keep going on, that he's got to work on staying sober, he's got to work on working programs, and he appears to be committed to do that. So we would ask the court to follow the recommendation. Thank you.
Thank you. Mr. Summers, anything you wanted to say today?
Yeah, I would apologize to the court for any inconveniences I've caused. It's been a long road. I've been sober just over 2 years. Basically, I just want to apologize for the inconveniences not showing up. And hopefully.
All right. I did read through the report, so I'm familiar with all the circumstances as the lawyers have indicated here on the record. And I mean, basically, I agree with what they have said, which is, at first blush, this is a case where typically I would impose a different penalty and frankly, a harsher penalty based on failure to appear. But given the circumstances here, I don't think that's necessary. I think, you've been incarcerated here since mid-July, so you've got almost 45 days of credit. 47 total based on some credit from before, but I think that's an adequate sanction here to address your failure to appear. And I think overall, given what's occurred during the interim, I don't think the imposition of additional penalties here is going to serve the interests of the community or really serve the interests of rehabilitation for you. I think having you being able to continue with that is more important. So the court is going to follow that recommendation. The court is going to send you to 47 days in the Kalkaska County Jail with credit for 47 days served, crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, and estate costs of $68. You do have the ability to request an appeal of this sentence. And Mr. Travis, you can have Mr. Summers' acknowledgements.
He has executed the receipt and does have the forms.
Is there anything else that we need to address on this file today?
Thank you.
Mr. Summers. Okay, is Mr. Pachaki here?
He is, Your Honor.
Do you want to come forward, please?
English.
Okay, Ms. Brenner, are you able to hear me okay?
Yes, Your Honor, good morning.
All right, good morning. We're on the record now in People versus David Taichaki. This is case number 234781. The record should reflect that the defendant's present here in the courtroom today. If I could have both counsel put your appearances on.
Sarah Brenner, Assistant Attorney General for the people, Your Honor.
Kyle Travis on behalf of Mr. Patchak.
Okay, this is set for a hearing on a delay of sentence, and the court is in receipt of kind of an updated evaluation plan. Mr. Travis, did you and your client receive that?
The updated PSI, yes, and we have an update to that.
Okay.
As referenced in the PSI, Mr. Patchak was planning to pay off his balance. He did do that this morning. I haven't just got it, so I haven't sent it to Ms. Brenner, but we did drop a copy up with Ms. Wagner just minutes ago. But we do have a copy of receipt if the court would like to see that from OC.
All right, so that's going to supersede because I wasn't email from yesterday indicating that had not been paid yet. So
That is correct, Your Honor, and it was just paid this morning.
okay, so Ms. Brenner, just so that you're aware, I'm in receipt of a receipt from Mises that indicates that Mr. Paichaki made a payment in the amount of $3,422.08 today.
Okay, Your Honor, can we adjourn this a week or two so we can make sure that the money's clear? And then we can come back and effectuate the sentencing at that time. I just want to make sure that the monies go through like they're supposed to. I've had times where I've gone through and then the monies don't go through, or there's a stop payment or something like that happens. So I'm always more cautious when it's paid at the last second.
Well, I don't know if we would object to that, Your Honor, but Mr. Paichaki is indicating it was paid in cash, it wasn't a check.
And that very well may be, I don't know. I mean, this does indicate, I mean, Ms. Brenner, just so you're aware, the receipt that I have shows that the payment was made in cash. Does that change anything about your request?
Well, that does help, but did he pay it through directly to the front of the court or through the Mises system or?
Look, it looks like it was through the front of the court here in Kalkaska.
Okay, and I do show that that was the amount that was owing as of the end of August. He will have his September order that he'll need to pay. So Your Honor, I can see the payment in the system since it was done in cash. I am okay with going forward with the sentencing on the reduction to the misdemeanor disorderly person then today.
Okay, very good. Thank you. All right. So all of that being said, Mr. Travis, do you have any other corrections or changes that you can make to the paperwork?
No, Your Honor.
Ms. Brenner, was there anything that you wanted to or needed to correct or change about the PSI or the paperwork in this case?
Your Honor, do you want me to prepare an amended information adding account 2 for the misdemeanor disorderly person? And then we would have him withdraw his plea to the count 1, enter the plea to the count 2, and sentence him accordingly?
Yes, exactly.
Okay.
All right. Mr. Travis, anything that you wanted to say on behalf of your client here today?
Just, Your Honor, it took a minute, and it has, obviously, it's a financial thing, and finances are tough, but he did meet his obligations. I think even as we saw, he was doing a good job of paying his regular support during the course of this, and fortunately was able to come up with paying all the back support. I think he understands the importance, obviously, of staying current, and that's his intention. His employer is here in support of him, and hopefully going forward, he won't have any more issues with this.
All right, thank you. Ms. Brenner, anything that you wanted to say on behalf of the people?
I just wanted to congratulate the defendant. Good job, sir. I'm glad that you've been able to step up and provide for your children in this manner. And Your Honor, I would just be asking for time served and whatever fines and costs are mandatory.
Thank you. Thank you. Mr. Paichaki, anything that you wanted to say today?
No, Your Honor.
I guess my only question let's see, Miss Wagner, we still have court ordered obligations that are left.
Yes, Your Honor, those were the ones that were originally ordered at the time of his initial sentencing. I'm not asking for any further probation time for that. He could probably enter into a payment agreement with the court if the court allows.
Okay. All right, thank you. So the court, Mr. Pachaki, under the agreement, you would be withdrawing the plea to the felony, and that would be changed to a plea to a misdemeanor. Do you understand that?
Yes, sir.
Okay, is that how you want to proceed?
Yes, sir.
All right, the court finds based on the record before it that Mr. Pachaki, that you have complied with all the terms of the delay. The court is going to preserve the court ordered obligation. So once you leave court today, you need to go to the clerk's office across the way to make arrangements to pay those off, because that's still $722 still left. But in light of the fact that you have paid the full balance of the owed child support, the court will effectuate the agreement that was made before. The court will order that you serve 5 days in the Kalkaska County Jail with credit for 5 days served. And again, preserve those outstanding fines and costs. Because this was pursuant to a delay, there are no appellate rights at this time. Mr. Travis, anything further that we need to address?
Nothing further. Your Honor. Thank you.
Ms. Brenner, anything further that we need to address for the record?
No, Your Honor, thank you. And I will submit that documentation for your files.
Okay, thank you. That's all for today, Mr. Pachaki. Good luck going forward.
All right, thank you.
Thank you, Judge.
Mr. Travis, were you ready with your next case? Or do you need a minute?
Just.
We're a little ahead of schedule, so. We'll take a short recess and we'll come back on the record. In about 5 minutes. People versus Sarah Household, case number 234824. I'd like to have council put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mrs. Household.
Mr. Travis, how did we want to proceed on this file today?
Your Honor, we have come to a plea agreement, and it's my understanding this household would like to accept that. We did have a request relative to sentencing that we can address after that, but Ms. Household has a surgery planned at the end of this month.
Can you tell me what the?
Yes,
Let me find the information real quick here. Okay. Terms of the plea agreement, please.
so Your Honor, it would be to plead, actually, truly the plea is plead either count 3 or count 4, dismiss other counts and other enhancements. Ms. Household would plead to count 4, and all other counts and enhancements would be dismissed. Obviously, there's a restitution in this case. We do not have a set figure yet, but we do understand that there will be a restitution as part of this too.
Okay, Mr. Ziegler.
That's correct, Your Honor, and just so the record's clear, it would be a restitution, even including any restitution as to the dismissed count, so it would be full and complete restitution as to all offenses contemplated by the conviction.
Mr. Travis, is that correct?
That is correct, Your Honor.
Ms. Housel, have you had an opportunity to speak to Mr. Travis and go through this plea agreement with him?
Yes, sir, I have.
Okay, and what we've discussed here on the record, is that the same things that you've discussed with him?
Yes,
Is that how you want to proceed today?
yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank you. Ms. Housel, are you currently on any kind of probation or parole?
Yes, sir.
You understand that by pleading guilty to count 4, which is stealing or retaining a financial transaction device without the owner's consent, if that's a felony, that carries with it a maximum possible penalty of up to 4 years and or a $5,000 fine.
Yes, sir.
And you understand that as part of this agreement, you're going to be required to make full restitution in whatever amount that is.
Yes, sir.
With all of that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are in fact guilty of this charge?
Yes, sir.
Okay, so the information that I have indicates this happened back in March of 2022. Is that the correct time frame?
Yes, sir.
And at that time, were you present here in Kalkaska County?
Yes, sir.
And did you have a credit card? Is that what we're dealing with here? Credit card?
Yes, sir. Maybe I could ask
Yeah,
some
go ahead.
questions.
Yeah, please.
So you had gotten back or at a certain point had your mother's credit card, correct?
Yes,
And she had passed away prior to this?
yes,
And it was just your mother's name on the credit card, correct? But you did during this period use the credit card
yes,
and it was not your credit card to use.
correct.
You didn't have any permission or consent from anybody to use that card?
No, my mom was passed away, so she couldn't really give it at that time.
No
I
one
did
else,
before, but
no one else would have been authorized to give you permission?
No.
Mr. Ziegler, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute, and court ruling, and taken the plea?
Yes, Your Honor.
Mr. Travis?
Yes.
Thank you. Ms. Hausel, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with Agent Barrett to set up a time for a pre-sentence report. It's just important that you make sure that you stay in touch with Mr. Travis prior to the sentencing date so that you're prepared to go forward at that time. Mr. Travis.
Yes, Your Honor, could we address the sentencing date? We would ask the court to set this out 2 months. I would like to see Ms. Also, I believe it was last week when she was talking to her doctor, basically was informed that she needed to get a surgery as soon as possible. That is set for September 25th. It's a myocardial valve or mitral valve reconstruction, so a fairly serious surgery. So we would ask the court to rather than setting this on the next date, set it 2 dates out, so she would have basically some time to get the surgery done and to be healed up and ready, because potentially she might still be in the hospital or at the very least still recovering from that if we set it for the early October date. Thank you, Your Honor.
Mr. Ziegler.
Your Honor, the other issue in this matter is that figuring out what restitution is owing and to whom might be somewhat complex. So I wouldn't mind having the extra time in any event to try and sort the restitution issues out. So I have no objection to the defense's request.
Okay, so we'll set this for sentencing in November. The court will send out notice of the date and time of that hearing.
Thank you very much, Your Honor.
Thank you. That's all for today.
Thank you.
People versus Roseanne Stover, case number 244924. Okay, and Ms. Stover's present here today. If I could have counsel put your appearances on in this file.
Ryan Ziegler.
Al Travis on behalf of Mr. Stover.
And I believe this is kind of a plea cutoff here today. Mr. Travis, can you tell me where?
Yes, Your Honor. Unfortunately, sobriety court declined to accept Mrs. Stover, not because of necessarily her behavior while on bond or anything, but she had previously been in the program and they elected to not offer her another opportunity. So even though I think she probably would have been a good candidate, she thought she would have been a good candidate. That's not an option. So we are here. The prosecutor's offer is plead to an operating while intoxicated third with no enhancements and to dismiss the other misdemeanor charge. Ms. Stover would like to accept that plea.
Is that a correct statement of the plea offer, Mr. Ziegler?
It is, Your Honor.
Ms. Stover, is that how you're choosing to proceed today?
Yes.
Okay. Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Thank you. You can lower your hand. Are you currently on any kind of probation or parole?
No.
You understand that by pleading guilty to count 1, which is operating operating while intoxicated with a high BAC as a third offense, the maximum possible penalty that you could face would be up to 5 years and or a $5,000 fine. Do you understand that?
Yeah.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yeah.
And you understand that by pleading guilty, you're going to be giving up and waiving all of those rights.
Yeah.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to do that, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yeah.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we said here in court today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are guilty?
yes,
This happened on January 22nd of this year. Is that the correct date?
yes,
On that date, had you been consuming alcohol?
yes,
And after you consumed alcohol, did you operate a vehicle specifically at an Arco gas station here in Kalkaska County?
yes,
And at the time that you were operating that vehicle, you had been consuming alcohol prior to that, correct?
yes,
Okay. Did you have any blood or breath tests to determine the level of alcohol in your system?
yes.
Do you know what that was?
I can't remember, to be honest.
Was it above 0.08?
Yeah,
Okay. You know if it was above 0.17?
no, I'm not.
Don't know. Okay. Do you have any reason to doubt the accuracy of the test that showed that your blood alcohol level was above the legal limit?
No, I don't.
Mr. Ziegler, do we need to establish the high BAC element here? Is that going to make a difference?
Your Honor, I don't know that it really makes a difference because it's just the predicate for the third, but the blood test was 0.298.
Okay. If that was the blood test result, again, Ms. Stover, do you have any reason to doubt the accuracy of that test?
No,
Had you previously been convicted of operating while intoxicated in 2014 in the Fifth Circuit Court?
yes,
And also in 2017 here in the 46th Circuit?
yes,
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Ms. Stover, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. You're going to meet with Agent Barrett before you leave court here today to set up a pre-sentence interview. And then the court will set this for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney, Mr. Travis, prior to that time, okay?
okay, thank you.
Thank you.
There, Wexford, can you tell me your name, sir? Mr. Stickney, okay, thank you. All right, we're on the record in People versus Nathan Stickney. This is case number 244937. The record should reflect that Mr. Stickney's present by video from Wexford County. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Nathan Stickney.
Thank you. Mr. Travis, have you had a chance to talk to Mr. Stickney about how we're going to proceed in this file?
We have, Your Honor. It is my understanding we're going to accept the plea offer. My understanding of that plea offer would be count 2, which is a home invasion first degree. All other counts and enhancements would be dismissed upon that plea.
Mr. Ziegler?
Fair statement of the offer, Your Honor.
Okay. Mr. Stickney, were you able to hear that?
Yes.
Okay, have you had an adequate opportunity to speak with Mr. Travis about that plea agreement?
Yeah.
Is that how you're choosing to proceed today?
Yes.
Could you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Stickney, are you currently on any kind of probation or parole?
I am not.
You understand that by pleading guilty to count 2, which is home invasion first degree, that is a felony that carries with it a maximum possible penalty of up to 20 years and or a $5,000 fine.
I am.
With that maximum possible penalty in mind, what is your plea to that charge today?
It is guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want to. You understand all those rights?
I do.
You understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are guilty?
Yes.
Okay, this happened on, it looks like either the evening of April 4th or the early morning of April 5th of 2024. Is that the correct time frame?
It is.
And during that time, did you enter into a home at 9861 County Road 571 here in Kalkaska County?
I did.
Okay. And did you have a weapon with you when you did that?
I did.
Okay. Was a firearm a rifle? Is that correct?
It is.
All right. Mr. Travis, are there any other comments we need to address here? Mr. Ziegler?
While present, entering or exiting, committed an assault there, Your Honor.
Okay. Do you know the facts here?
Yes.
Okay.
Mr. Stickney, is that your stepfather's home?
It is.
And did you and he, did you physically assault him after entering the home?
I did.
I think that.
Mr. Ziegler, are you satisfied with that?
I am, Your Honor.
All right. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Stickney, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied based on your testimony that there is a factual basis that would support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll have this matter set for a sentencing hearing. You'll be notified of the date and time of that hearing. That'll be in person here in the courtroom in Kalkaska. In the meantime, somebody from the probation department will be in touch with you to prepare a pre-sentence report. Mr. Ziegler, anything else that we need to address on this file today?
No, Your Honor.
Mr. Travis?
No, Your Honor.
All right, thank you, Mr. Stickney. That's all for today.
All right. Have a good day.
Do you know if we have Mr. English here?
Yes.
Have we seen Mr. Horowitz yet?
No.
Can we check and see if Mr. Horowitz is up? I'm just going to take a short recess and be back on.
I'm not, Your Honor. I was previously Mr. English's attorney. Actually, he requested his counsel and has Mr. Horowitz. I did get a chance to speak with Mr. Horowitz. I think he miscalendared or didn't understand, but he is on his way here because he does have an 11.
Oh, he is on his way here.
Yes, he's got an 11 o'clock. He just, I don't know exactly what happened, but he was planning to be here at 11. And
Okay,
he's on his
so,
way.
so we're gonna hold off until 11, so. thank you. We're gonna recall your case in just a few minutes, Mr. English.
Oh, this promotion to all have required, so.
Okay, we'll address that for you. Are you ready on Mr. Mattis's case?
Yes, who is in the court here?
This is file number 44914, People versus Brennan Wisnitis. And this is the date and time set for a hearing in this sentencing hearing in this case. I think I left it.
Oh.
And Your Honor, we do have, there's 2 letters that were attached to the PSI. Mr. Rosani's has a 3rd letter that Mr. Ziegler did just briefly look at, if I could. give it-
Yes, please. So again, this is the date and time set for sentencing. We'll address this in just 1 minute. Mr. Wisnitis, have you had an opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yes, Your Honor.
Okay. And Mr. Travis, I did have a chance to review that letter. That's from recovery coach Daniel Meyer. Did you want that attached to the PSI?
Yes, please.
Okay. So the court will attach that to the pre-sentence report. Are there any other additions, deletions, or corrections?
Not that I'm aware of, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, I've had an opportunity to review the recommendation contained in the PSI. Typically, I'm supportive of recommendations in PSIs, but in this case, I cannot comprehend the recommendation by the department in this case. The recommendation for a term of probation for 3 years. The guidelines in this case are 10 to 23, so that would be a significant downward departure. And I can't find any justification for that on these facts. Just a few things that I would point out, and I'm sure the court's already noticed in the recitation of the PSI. This is the defendant's 5th OWI conviction. Clearly, he has a problem with substance abuse, and he's been given opportunities in the past to address it. He's had multiple unsuccessful terms of probation. He's gone through the sobriety court program, which to his credit, he did complete, but now just a short time later, he finds himself back before the court for another OWI offense. In this particular case, not only was he driving under the influence, but he led law enforcement on a dangerous pursuit, speeds of over 90 miles an hour, clearly a danger to himself, to law enforcement, and to other motorists on the roadway. And I would also note that in November, he failed to appear, a bench warrant was issued, and he absconded for over a year. All of those facts do not suggest to me that this case is deserving of a downward departure. I think a sentence in the middle of the guidelines at least is an appropriate sentence. We've given Mr. Wisnitis many opportunities in the past on probation, on lesser sentences, on community sanction before, and he continues to reoffend. So I would ask the court to give him an MDOC sentence somewhere in the middle of the guidelines. Thank you.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, much of what the prosecutor is saying is true. Part of where, and I don't know exactly why MDOC recommended what they recommended, but I would note, Mr. Wisnitis, in the interim, did a year in jail in Genesee County in this period when he wasn't with us. And out of that, he has been placed on probation. He's been on an alcohol tether. He's been on a GPS for the past 4 months. About 4 months, he's been successfully on probation. There again, this is a situation where he did not come to court, but in the interim, he spent the last year in jail downstate. And now he's served that year sentence and he's doing well on probation. They placed him on 3 years of probation. And that's why we provided the letters. He clearly has a substance abuse problem, but he comes to the court doing quite well managing that. After a substantial term of incarceration and getting a start on doing well managing that problem, he's as indicated by the letters, he's doing the programs he's asked to do, he's doing things he's asked to do. I guess I maybe took the recommendation a little bit differently, and I explained it to Mr. Wisnitis differently. I don't think Your Honor has to depart to follow the recommendation. The box is left open for Your Honor to enter jail time. He did get some credit for the jail time he did, but he didn't get, obviously, under the case law, the credit for after he was sentenced. So there's a significant chunk of jail time that he did that he's not getting credit for, and he's not entitled to that. That's the way it is. But he's had a lot of time in jail. But I think Your Honor could give him a 12-month sentence and place him on 3 years of probation, which would unfortunately put him back in jail for a good period of time before he started this probation. So that is not the way I did not interpret the recommendation to say just put him on probation. I explained it to Mr. Wisnitis as if the judge follows the recommendation, he's probably going to give you 10 to 12 months in jail, and you're going to have to go to jail. So we would ask the court to do that. He is on a good path. He is doing better. He clearly has a substance abuse problem, and he's granted under some pretty strict being on bond in this case and felony probation in the other case, but he's been doing well for the last 4 months. And that's his focus, is to continue to move forward, to continue to be there for his children, and to continue getting back to where he once was with work and earning capacity. He's still not anywhere near where he has been in the past. And in the past, he's been a foreman for pouring basements and poured walls. He's not there yet, but he has hopes to get back to being a responsible and someone who could be trusted to manage a product and manage other employees again. So we would ask the court to follow the recommendation. We understand his record is not good. I would note, until this most recent period in Genesee County, he'd really only ever done a couple months in jail. So in talking to him, I think that year in jail did have quite an effect on him. And understanding that I think more time in jail, which Your Honor can do, would also have quite an effect on him. Thank you, Your Honor.
All right, thanks. Mr. Wisnitis, anything you wanted to say today?
Yes, Your Honor. First and foremost, I want to apologize to the officers of Kalkaska for my actions in drinking and driving. I knew it was wrong. I had, prior to this, I had 4 years of sobriety, and I know I had trouble, before that even, and I knew it wasn't smart to be picking up alcohol and smoking marijuana, and that's what I had been doing. And I came up here to work, not to come up here to drink. And I've lost everything through this, and I'm trying to move forward. I'm working with the recovery coach at the probation department. I'm working with the counselor now through Odyssey House. I'm following my terms of probation, and I have no means. I don't want to be leading that direction. I don't want to be a leader and have people looking up to me as that person to sit in a vehicle and drink after work. I don't want to be that person in and out of penitentiary systems and jail my whole life. I got 2 sons that I care for that are counting on me. They're just starting football, and I'm gonna have to miss that. Before. I mean, it's been a road, and I know what alcohol does, and in the end, people like me end up sitting in prison, or making that mistake and there's no return, and I don't want to live my life like that. I got loved ones that count on me. And from here, I'm moving forward. I'm gonna get another house when I get going again, get my job back, 4 walls, you know, to be a member of society in a positive manner, not a destructive manner. And I apologize for my actions up here in Kalkaska. Thank you, Your Honor. And again, I'm sorry to the officers. No, I shouldn't have done that. Just wasn't thinking. It's costing me now.
All right, I did read through the report, so I'm familiar with these circumstances here, and certainly conduct that caused, as Mr. Ziegler indicated, not just a danger to yourself on the road, but to innocent bystanders, people just on their way to work or home from work or whatever they were doing. Not to mention the officers having to use stop sticks to finally disable your vehicle to bring this to an end. You know, I think it's encouraging that you're doing the kind of things that you're doing in terms of treatment. There's no question based on your record that you're not somebody who can drink alcohol casually, because it's going to end bad for you. And so the sooner that you get that kind of help, better it's going to be for you going forward, because you have amassed pretty substantial history of drinking and driving offenses. You've been sentenced to jail 3 times previously, 6 times on probation. So there's been a lot of opportunities for you to get a hold of that problem. And the fact that you haven't indicates to me again that this is an issue for you, that you're going to have to make a decision sooner or later that you just can't ever touch alcohol again. Because not only do you drink to excess and then engage in dangerous behavior by operating a vehicle, but then you take it to the next level and we have a situation like this where there's a chase. In terms of the court's options for sentencing, I don't agree with the recommendation. You've been on probation a number of times. I think it's encouraging that you're doing well so far, but 4 months of positive time on probation, I don't think makes up for the negative times. You have had some successes, as Mr. Ziegler indicated, through the sobriety court program, but those haven't been lasting successes. And in my view, punishment and consequence should be a progressive thing. In other words, when lesser sanctions don't work, then it's the duty of the court to increase those in the hopes that at some point you're going to get the help that you need, and the message is going to sink in. So I don't view putting you on probation again as beneficial to the community or to you. I do think, given your history, that at this point a more progressive sanction is appropriate, and so the court is going to sentence you to the Department of Corrections for a period of 20 months to 5 years. You do have credit for 160 days served. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a state cost of $68. You do have the ability to seek an appeal of this sentence, and Mr. Travis, if you can have Mr. Wisniewski's acknowledge receipt. Mr. Wisniewski's papers are going to explain to you how to appeal this sentence, as well as how to request a court-appointed lawyer to help you with appeal. You are granted to the custody of the state of the Senate. Travis, do you have any of your clients that are in Clare?
Mr. Hiddles is, I just found out might be in Clare.
Okay, they disconnected. You're not turning on the camera. Do you have Mr. Almond? We're on the record in People versus Andrew Alleman, case number 224693. He is present here in the courtroom today, and this is set for the follow-up hearing. Mr. Alleman was sentenced into the Veterans Court program. My understanding, and I signed a successful discharge, that he did successfully complete that program. And has been successfully discharged from the probation here in this case. And so I think at this point, he would be withdrawing the plea of conviction and entering a plea, Mr. Travis, to a reduced charge. Is that correct?
That is my understanding, Your Honor. My understanding that would be to domestic violence.
Okay. Mr. Ziegler, do you have any additions, deletions, or corrections to the information I've just indicated in terms of?
Hey, the Zoom will bring my video up.
Go ahead.
No, Your Honor, that's all accurate. That's my understanding of what the plea agreement was.
Okay, and do you have any objection to proceeding pursuant to that agreement and allowing the reduction in the charge in this case?
No, Your Honor, I'm gratified to hear that he's done well in the Veterans Court program, and I think he's deserving of the reduction.
Okay, Mr. Travis, anything on behalf of Mr. Allen?
Your Honor, just that he did complete the program. He found it beneficial. He's taken advantage of VA services, addressed his own mental health issues, even physical health. He's in better fit, he's just taken advantage of what the program and the VA had to offer, is in a better position, and is looking to go forward. He may even, he's initially from California, he may even move and wants to look into taking advantage of his options under the GI Bill with pursuing education, because he is 100% disabled because of some physical issues, but on a positive note, he wants to pursue education and employment that doesn't require physical issues.
All right, thank you, Mr. Allen. Anything that you wanted to say today?
Yes, I do, Your Honor. I like to say, I'm sorry for what I've done. And it's no excuse for what I've done. At that point in life, I was mental turmoil. I lost who I was. And currently I'm on that path to find out who I am. And I continue to seek out the treatment, outpatient treatment from the VA, psychiatry and therapy as well. And I'll continue to do that. That's all I got.
Okay. Prior to the hearing today, I had a chance to go through the file and just kind of refamiliarize myself with your case, because it's been a while since you've been back in court here. And once I started reading into it, I remembered this case because it was one of those that I was concerned about at sentencing. And so I'm very glad to hear that you successfully completed that program. I think that probably took a lot of work on your part. And I think it's a really good outcome for you in particular in this case. I did not want to see it go the other way. And so I think you should be proud of the work that you put into this program and in successfully completing it. And I hope that gives you confidence and some heart going forward that you can stay on this path. But I was really glad to see that you successfully completed it. So congratulations on that. The court finds that it's entirely appropriate to grant you the benefit of the agreement that you entered into at the beginning of this case. So the court will order that your conviction be withdrawn and that conviction to just the misdemeanor domestic violence
Correct, Your Honor.
be entered. Do you need the code for that?
Thank you.
Do you have the pack? code?
It's 750.812.
Thank you.
And good luck to you going forward, Mr. Allen. I hope things continue on the right path for you.
I will.
Thanks.
Thank you.
Okay, Mr. Hiddle, if you can unmute on your end there. Yeah, Mr. Hiddle, you're muted on your side, so I don't know if you need to ask one of the corrections officers to help you with that.
It's unmuted.
Okay, great, thank you. You are Buck Eugene Hiddle, is that correct?
Yes.
All right, we're on the record now in People versus Hiddle. This is case number 234859. The record should reflect that Mr. Hiddle is appearing today by video from Clare County. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Hiddle.
Okay, Mr. Travis, it sounds like you, have you had a chance to talk to Mr. Hiddle at all since you?
We did get a chance to speak last week.
Okay.
It is my understanding, it's his intention to hire Mr. Slocum for this matter, so we would ask the court for a 1-month adjournment so he can facilitate that.
Okay, Mr. Hiddle, is that correct? You want to hire your own counsel on this file?
Yes, I've retained Jeff Slocum.
Okay. Do you have any objection to the court setting this out so he can make an appearance on your behalf?
No, that's fine.
Mr. Ziegler, do you have any objection to that?
Not particularly at this time.
Okay. All right. So the court will set this for a hearing at its next available date. You'll be notified of the date and time of that hearing. Mr. Hiddle, do you anticipate that you're going to be there in Clare County? For the next
Released. I'm getting released in 2 weeks.
2 weeks. Okay. Do you have an address that you can give us right now where you're going to be? Because I want to make sure we send your hearing dates to the right location.
Yes, the 8808 Landon Road.
That's the road. Landon. Okay. That looks like that is the address.
Okay.
Okay. So we'll send mail to that address. And you just need to notify Mr. Slocum to have him file his appearance here with us, okay?
Yes, sir.
All right. Mr. Travis, anything?
Nothing further, thank you.
Mr. Ziegler.
Nothing further, Your Honor. Thank you.
Mr. Hiddle, do you have any questions at all?
No, sir.
Okay, thank you. That's all for today. The court's going to disconnect at this time.
Thank you.
Thank you.
We'll take a short recess. We'll be on the record in about 5 minutes.
All right.
Okay. I'm just gonna run right across.
She's gonna grab that paperwork for you right now, Mr. Owens. Thank you. All right, Mr. English, I'm gonna have you go to the podium there, please. We're on the record in People versus Michael English. This is case number 244925. Mr. English is present here in the courtroom today. We got Mr. Horowitz present, as well as Mr. Ziegler. Mr. English, you indicated off the record earlier today that you're asking to have Mr. Horowitz discharged. Is that right?
That's not all of it that's on there. There's other stuff. My wife's the reason why I'm firing him is because he tried coercing her into saying that I was guilty of these charges. To make sense on the case.
Okay. Are you gonna hire your own attorney?
No, I'm gonna represent myself.
You're gonna represent yourself. Okay.
If I can't get another one appointed to me, I'm gonna represent myself.
Okay. All right, and so let me go through a few things with you. I mean, do you want to represent yourself, or are you saying that you're going to be forced to represent yourself if we don't appoint another attorney?
Yeah, if you don't, I'll be forced to represent myself if I can't get another one appointed to me.
Okay. All right, Mr. Horowitz. Well, Mr. Seeger, do you mind jumping in on this? I don't know. I know I'm catching you.
Yeah, Your Honor, I guess the procedure, at least as I understand, Mr. Travis was initially the attorney. And with Mr. Horowitz, generally speaking, I try and afford someone if they want a separate counsel on occasion. But generally, I don't want to get into the idea of forever rotating our attorneys for which the end result is going to continue to be the same. I might like an attorney for whatever reason. Access. But I have to say, certainly that it's not like whoever signs it.
Okay, so Mr. English was assigned Mr. Travis. He requested a different attorney, so then Mr. Horowitz was assigned. Is that what you've done as the administrator?
Yes.
Okay. So just for the record, Mr. Seeger is the MIDC administrator for Kalkaska County, and he's present at the back of the courtroom. I asked for clarification on the status of counsel, and he's indicated for the record, to the extent that the microphone didn't pick it up, that Mr. English was initially assigned Mr. Travis as counsel, that upon his request, Mr. English's request, he was removed and Mr. Horowitz was assigned. So Mr. English, you know, we don't have just a never-ending stable of attorneys to continue every time you decide you don't like one.
It's not that I don't, wasn't saying I don't like them, it's just they're not doing their job.
Well, what you believe to be their job. And, you know, again, that's a very subjective.
I've already wrote the assistant attorney general at Zen Pierce about this too, to report my complaints with them about Ziegler and Horowitz and Travis, so.
Right. So again, whether you think somebody's doing their job or not is a very subjective thing. And so it's not just up to you to decide, I don't like the way they're doing their job, and then I could appoint 5, 10 different attorneys for you, and you might decide you don't think any of them are doing their job. And then what do we do? I mean, do you think that I should just continue to appoint you new attorneys, and then when you decide that you don't think they're doing their job, I just choose another one? Like, how many should I go through before? I'm asking you.
I'd say I have to keep going through them, just, he's not doing his job, and he's trying to coerce a key witness in this case to admit that I'm guilty to him, then he should not be my attorney.
Okay. All right. Well, as far as I can see from the proceedings that we've had, Mr. Horowitz is adequately representing you. You may not agree with the advice that he's giving you. But that's not his job, is to tell you what you want to hear. His job is to advise you about what he thinks your best options are, and you may not agree with that. But I'm not gonna appoint another attorney for you. If you want to hire your own attorney, you're free to do that at any time. All right, Mr. Horowitz, I'm going to have you remain counsel of record, so that if Mr. English decides that he wants to consult with you, that he could do that. This isn't a standby appointment. I'm going to have you remain counsel of record, but I'm going to address Mr. English individually. And then if this is going to go to trial, we'll figure out how we're going to proceed on that.
Understood. Thank you.
But at this point, I don't find that Mr. English is making a knowing and voluntary and unequivocal waiver of counsel when it's based on he wants different counsel and the court's declining to provide that. So then he wants to represent himself. I don't think I can find that's again a voluntary, knowing and unequivocal waiver of counsel. So, Mr. English, how do you want to proceed with your case? Do you want your options would be to enter into some kind of plea agreement with the prosecutor, or
Not doing no agreement.
to go to trial?
I'll take it to trial.
Okay. All right. Mr. Ziegler.
Subpoenas for my witnesses.
Yep, Mr. Horowitz will help.
He's not my attorney.
He is your attorney.
Nope, I am firing him and I'm doing it myself.
That's not your choice at this point.
Yes, it is my choice.
No, it's not.
Then I will be filing a motion to have you taken off this case too.
You're free to file whatever motions you would like. But he's going to remain your attorney. You can choose to work with him or not. That's up to you. But he'll be preparing your case and presenting your case in front of the jury. Yes, he will.
No.
Yes.
No.
You're not in charge here. Okay?
You're not in charge either. Because I will be, like I
I
said,
am in charge.
I've already wrote the judges, the Michigan Judicial Tender Commission about you too, so.
You can do all of that, but
I've
until
reported
they do
you, so
something.
you are under investigation along with him and him, so you're not, no.
That's fine, but until
I'm
that
not having him
happens,
represent me, so no.
until that happens, I am in charge. Okay, so you can say whatever you want, but that's the facts. You can accept those.
Facts is that he's not my attorney.
He is your attorney.
No.
Okay.
I will be filing.
Mr. Ziegler, how much time do you need to be ready for trial?
Your Honor, we could be ready within 90 days.
Mr. Horowitz, understanding that
you
you
don't
have
have
difficulties with your client, is that enough time for you to do?
Yes, Your Honor.
Mr. Ziegler, how many days of trial do you think?
Your Honor, I think 1 day on each file would be sufficient.
Okay, I think we just had one. We have 2 files up for today.
There is a second file, Your Honor. There's only
Yeah, I
one
think we
out
just
for
have
today.
Are they going to be joined for trial?
They are not, Your Honor. There's separate incidents. I believe they occurred on different days. So I wouldn't be filing any motions for joinder.
So is 4925, which is the file we're dealing with today, would that be the earliest in time?
It would, Your Honor.
Oh. So we'll try that one first. You said 1 day?
Yes, Your Honor. I think that would be sufficient.
All right, Mr. Horowitz, do you think 1 day would be enough time?
I think the only thing that it depends on is if Mr. English has witnesses that he wants to be subpoenaed. That could affect the length of the trial. But at this point, I don't know that he will provide me the list of which witnesses he wishes to have.
Was fleeting on looting? I have a whole list.
Okay, so we'll set this, I'll set it for 2 days, as you say. We'll set it for a jury trial. Mr. English, please, I'm trying to make a record here.
I'm giving him my list. Shut up.
You say that again, I'm gonna find you in contempt.
Go ahead.
I'll find that you're in contempt. I'm gonna sentence you to 90 days in the Kalkaska County Jail for direct contempt. And the court's gonna order that that be served consecutive with any sentence that you might receive in this case.
Okay, you go fuck yourself.
Okay. We're gonna have Mr. English removed from the courtroom at this time. He's obviously not gonna participate meaningfully in his own hearing.
You can go fuck off. Fuck a little bitch.
Ms. Ziegler, I'm going to ask that you follow the typical procedure of submitting jury instructions prior to trial. Mr. Horowitz, all you need to submit is any instructions that are additional or different than Mr. Ziegler's or any objections that you might have. The court will set this for one final status conference plea cutoff. On the court's motion day immediately preceding the trial date. Mr. Ziegler, anything further that we can address from your side today?
No, Your Honor.
Mr. Horowitz?
No, Judge, thank you.
Okay. Thank you. The court will send out notices of the date and times of those hearings and go from there. For the record, just so council's aware, the court's going to prepare a judgment of sentence on the contempt charge that I'm proposing for Mr. English's behavior here in court today.
Thank you, Your Honor.
Do we have Mr. Griffer here?
He is here, Your Honor.
Okay. On the record in People versus Justin Griffer, case number 244915. Like that, counsel, put your appearances on.
Brian Ziegler, on behalf of the people, Your Honor.
Good morning, Your Honor. Lauren Kreinbrink appearing for Mr. Justin Griffer, who is still making his way through security, but is here.
Can you just spell your last name for me?
Yes, Your Honor. It's KREINBRINK, and my P number is 81230.
All right, correct. Right up at the podium there, the record should reflect Mr. Griffer's present. Mr. Griffer, so you're aware, I expect people to be here on time.
Sorry, sir, I was waiting for a ride.
Okay. Need to make arrangements to make sure that you're here on time from now on. Okay.
Yes, sir.
Ms. Krennerink, this is set for a final status conference today. We have trials set to begin on September 19th, a two-day jury trial. This is also the cutoff. Have you had an opportunity to go through the plea offer with Mr. Griffer?
Yes, Your Honor, at length. And it's my understanding that we have adjustments to take advantage of the plea offer. If I could place that on the record, Your Honor.
Please.
Your Honor, it's my understanding that Mr. Griffer would be entering a plea today to count 2, that being fleeing and eluding in the 4th degree, count 4, carrying a concealed weapon, and also an added count 6 of possession of methamphetamine. In exchange for those pleas, Your Honor, it's our understanding that counts 1, 3, and 5 and the habitual offender notice would be dismissed, and the prosecution would agree not to issue any charges related to the cocaine recovery.
Okay, so counts 2 and 4 with no enhancements. Sorry, I missed that.
That's my understanding, Your Honor, and also an added count 6 of possession of methamphetamine.
Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Griffer, have you had a chance to discuss this plea agreement with either Albert or Ms. Krennerink?
Yes, sir.
Okay. What we've said here in court today is that what you've discussed. You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth. Mr. Griffer, are you currently on any kind of probation as well? Eluding, that is a maximum possible penalty of up to 2 years and or a $500 fine and suspension of your driver's license for 1 year. And count 4, which is carrying a concealed weapon, that's carries with it a maximum possible penalty of up to 5 years and or a $2,500 fine and mandatory forfeiture of that weapon. And then the added count 6, which is possession of methamphetamine, as Ms. Kreiner indicated, that has a maximum possible penalty of up to 10 years. Do you understand that? With all of those penalties in mind, what is your plea to each of those charges today? Guilty. Right now, you have certain rights. I'm gonna go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all of those rights. Yes, sir. And you understand that you're giving up and waiving all of those rights by pleading guilty, including the right to have a trial. Yes, sir. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that? Yes, sir. Has anyone threatened you with anything to get you to plead guilty? Yes, sir. Has anyone promised you anything other than what we said here in court today? Yes, sir. Is it your own free choice to plead guilty? Yes, sir. Are you pleading guilty because you are in fact guilty of each of these charges? Yes, sir. The information I have indicates this happened back on February 9th of 2024. Is that the correct date? Yes, sir. Okay. On that date, were you here in Kalkaska County? Yes, sir. Okay. Were you operating a motor vehicle on a roadway somewhere here in Kalkaska County? Yes, sir. Okay. And while you were operating that vehicle, did you encounter Kalkaska County deputy in their police car patrol vehicle? Yes, sir. Okay. And did they either use lights or sirens or some other type of signal that indicate to you that they wanted you to stop your vehicle? Yes, sir. And did you fail to do that? At the time that you were operating that vehicle, did you have a weapon in that vehicle? Yes, sir. Was that a pistol? Yes, sir. Did you have any legal right or license to carry that weapon in that way in that vehicle as you were carrying it? No, you didn't. No, I didn't. At that time, did you also have possession of some methamphetamine? Yes, sir. Did you know that that's what that substance was? Yes, sir. Did you have any legal right to have possession of any amount of that at that time? No, sir. Thank you. Mr. Ziegler, are you satisfied with the factual basis as to each of the three charges?
I am, Your Honor.
Ms. Kreinring?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Ms. Kreinring?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Ms. Kreinring?
The defense is satisfied, Your Honor.
Thank you. Mr. Griffer, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing along with your attorneys. You need to make sure that you stay in touch with them so that you're prepared to go forward on that date. Before you leave today, you're going to meet with Agent Barrett to set up a time for a pre-sentence report. And that's all for this file today. The court will adjourn the trial dates based on the plea here today.
Thank you.
Thank you.
Can I get the PAC code for that adage count?
333.7403, 2B as in boy, 1.
Thank you.
Okay. CSE Incorporated versus Tabitha Kibbe, case number 2414447. And is this, are we here for purposes of a debtor exam?
Yes, Your Honor.
Okay.
Lisa Hall on behalf of CSE Inc.
Ms. Hall?
Yes.
Is that correct? Okay. All right, and you're Ms. Kibbe? Yes.
Or
Jones now,
yeah. Okay, so council, typically what I do is I just swear the individual in and then allow you to find a quiet place where you can have your discussion.
Thank you, Your Honor. We did reserve, I think room 114 is what we were told, so
Okay, great.
thank
So
you.
Ms. Kibbe Jones, if you can raise your right hand, please. You solemnly swear or affirm that any of the statements or testimony that you will give today will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Thank you, Your Honor.
Okay, last case for the morning, and this is a suppressed case.
and then they just disappeared.